Hi, I'm Kathy Sandweiss at Jaburg and Wilk. I'm an appellate lawyer here. A journalist once said that an appeal is putting the dice back in the box and trying again with another throw. It's not exactly that random, but it's not an exact science either. What we're doing is asking one set of judges to reverse another judge, a lower court judge. And really it's going to depend on what the standard of review is in your particular case. Whether the new judges decide that the old judge, the lower court judge, made an error. So we're looking for a legal error rather than a factual error, hopefully. Because if it's a legal error, it's reviewed what's called de novo. And what that means is that the appellate court will look at it for the first time and be sure that there are no errors legally. If we're looking for a factual error, the appellate court will say it gives deference to the trial court and deference to the fact finder, and it's a much tougher standard of review. The first thing we do is determine whether you have a final appealable judgment. If you do have a judgment that can be appealed, then there's a number of steps that have to be taken. The first one is to file a timely notice of appeal. Then there's a docketing statement which tells the Court of Appeals what kind of an appeal it is, if there is a final appealable judgment, what the issues are for appeal. After that, it's a fairly simple process with not as many steps as you're used to in the trial court. There's basically 3 briefs. As the appellant, the person appealing the judgment, you'll have an opening brief and a reply brief. The appellee, that's the person who wants the judgment affirmed, will have an answering brief. That process takes 3 or 4 months, not a lot. At that point, we're waiting for the Court of Appeals, which again would be a 3-judge panel. We're waiting for that court to either set the case for oral argument or for a conference. Once they do that and they either conference it or hear an argument, at that point, I can't tell you how long it's going to take, and that's always the big question. How long is this going to take? We don't know after that. There have been times we've gotten a decision 2 weeks, 3 weeks after the court conferences, but then we've had times that have been a year and a half until we receive a decision. And a lot of it depends on the novelty of the issues, the complexity. Sometimes it's just something sort of mysterious to us. At the Court of Appeals, they're not agreeing perhaps on what the decision should be, if it should be a memorandum decision, which is unpublished, if it should be a published opinion. And so it could be then anywhere from 6 months to 1.5 years, perhaps even longer if we're in a different type of court, the Ninth Circuit. But state courts, I would say, typically up to a year and a half before your appeal is concluded.